ready to be the bench, correct?
I don't know what it is you want to address.
Just an objection and request for a proffer of some testimony I think the state is about to present concerning some school records or school information, or coursework taken by my client some year or two before this event. And just a general relevancy objection, I would ask it be proffered, and then if there's any relevance whatsoever, that would be outweighed by its prejudice. And I just have concerns about putting in portions of a school book that he may have read in the course that he had 2 years ago, and that's my objection. So I would ask it to be proffered and its relevancy be shown.
Okay, response?
Yes, Your Honor. Actually, there are 4 different records, 4 different witnesses. The first is, generally speaking, a transcript of the defendant's coursework towards his degree in criminal justice at Seminole State College, and that shows that he took 149 hours, I believe, altogether towards that degree, including a number of classes over a number of years. Was on schedule to graduate, although hadn't yet. So that is record number 1. Record number 2 is one of the courses that he took, specifically taught by Professor Alexis Carter, and some of the homework assignments that he performed for that class. For the record, that course was titled Criminal Law and Procedure. It involved, as Professor Carter will indicate, discussions extensively of a number of Florida laws, including self-defense and the stand your ground law. Record number 3 is a application to be a police officer for Prince William County in Virginia, and simply the application and the fact that he was not accepted for that position. That is it. And then the 4th is a record of a Sanford Police Department application to ride along with police officers. Those are the 4 records. As I understand it, the objection is relevance as to each of them. Obviously, they all go to support a number of things, not the least of which is the state's underlying theory that this defendant had such an interest in law enforcement and law enforcement work that this is what he is. This is the position and the frame of mind that he is operating from at the time. In other words, this is what he wants to do. He wants to catch people. In fact, one of his homework assignments, he specifically mentions that. We believe that his chosen major, which actually has been mentioned in other evidence already, that he was seeking a criminal justice, is relevant to show that he has the education and the ability and the understanding, and has at least the background to be able to adequately discuss when he is confronted with police, both understand what it is that they might be trying to do and also what it is that he might say in order to address the situation in the light most favorable to him, legally speaking. I think as far as his knowledge of the law, that certainly would be relevant to his statements and his state of mind while making them, particularly as we just heard him tell Sean Hannity on national television that before this case he'd never heard of the stand your ground law. That would be directly contrary to one of his professors. And the other 2 records, the application to in fact be a police officer, as well as to ride along locally, I think would be relevant again for the same reasons. This is a ongoing pattern of behavior, and it shows that this defendant has had that interest for some considering time, and that this is very important to him, that he be able to act and potentially become like a police officer. And it is the state's position that one of our arguments in this case is that that's what he was actually trying to do at the time of the encounter for which he's on trial in this case.
Okay, response?
Well, the response, Your Honor, is that it simply isn't relevant. What they're trying to do is use a transcript for number 1, trying to use a transcript that he did, so he didn't even complete the degree, but to the extent that they're going to try and put before this jury that he went to community college seeking a legal studies degree is of no relevance to them. This event is supposed to have occurred within 7 or 8 minutes, exactly what happened that day. We have taken pains not to get into Trayvon Martin's school records and his past because we know that they carry a level of protection that they're supposed to protect. In this case, what they're trying to say is that because he went to college, because he went to high school, because he went to 1st grade, maybe even because he had a civics class, that is going to be able to get before this jury so they can focus not on evidence, not on hard and fast evidence that they have, but on some theory that he acted in a way after going through what he went through that night that he knew to say to the cops something that he said it while the evidence supports it. All I'm saying to you is that if it's relevant to an issue, a material issue, then let him show what that relevance is. The idea of just doing a witch hunt, if you can, or at least a fishing expedition, to try and argue to this jury at some point that he went to college and even that he wanted to drive along with a cop somehow is a negative thing, somehow suggests that it's bad that he wanted to go to college. I don't see any relevance, and if there is any minor relevance, rather than just a fishing expedition, it's certainly outweighed because...
I don't understand when you say it's a fishing expedition
Well,
from the exhibits that they're intending to introduce.
okay, the fishing expedition part of it is what they're trying to say. They're trying to come up with some theory. They don't get to just say, Judge, it's our theory that he's a bad guy because he went to college, but in effect, that's what they're doing. Their theory is not supported, at least yet, and they're a week and a half into their case, hasn't been supported by hard, fast evidence suggesting the anger and the animosity they want to try and
I don't
get.
think what they're trying to introduce is, for that purpose, from what I heard Mr. Manti say, is for the Mr. Zimmerman's knowledge of criminal justice and techniques of investigation techniques, interview techniques. He did say on the interview that was played from the state's exhibit number 180, the interview with the Hannity show, when asked the question if he knew about stand your ground law, and he said no, he did not. So
That's correct.
that's one of the things. It's the state's saying that it's not a fishing expedition, it's to show that the defendant had knowledge through course review as to police techniques for interviewing. I don't know what the course information is going to indicate, what was taught.
Well, the reason why I call it a fishing expedition is then, honestly, where does it end? And that's why I'm suggesting it's a fishing expedition. Do you now, everyone who's gone to a 6th grade civics lesson?
That's not what they're seeking to introduce. They're trying to introduce courses that Mr. Zimmerman took in criminal justice or towards a criminology degree. It's not like they're trying to introduce that he took humanity classes or he took a 6th grade geography class. They're being specific. I haven't seen the exhibit. Presumably you have.
I'm not looking, sorry. I'm looking at it, I don't see anything that says stand your ground was the only thing he said he didn't have, but I'd have to look at it and see.
Well, there's 4 exhibits up there if you want to take your time to look at them.
As I said, Professor Carter will describe in detail the stand your ground portion of that coursework. It's not referenced by name in the book. That's why he's here live. But that's sort of just an aside. I want to make sure that that point was clear if we're going to argue about it.
Okay.
We're going to go, I guess, go back and forth a little bit.
Well, I would, again, I have not seen any of the proposed exhibits. I have no idea what you all are talking about in regards to each of them. If somebody would like to hand them to me, I'll review them.
Let me see the police out.
In order, Your Honor, 209, which...
Just 1 second.
Sure. 209, which is the coursework towards the degree, including a certificate from Professor Carter as to the specific class in question in which he awarded the defendant an A.
Well, these records are his college record that shows all other classes and what those grades are. I would agree that that's not relevant, and attached are grade change and academic record update form.
That is the record from Professor Carter awarding the grade for the particular class.
Okay, course title, criminal litigation,
Yes, Your Honor.
spring 2010. There's a diploma certificates application.
Which I believe shows the proposed graduation date of late 2012, 2013.
Is that the only class that, the criminal litigation, the others, there's a criminal investigation, I see?
Correct. The criminal investigation is the subject matter of the professor about which we had a discussion this morning, Professor Pleasance, and I have an update on that situation when we get to that point as well.
I don't know that all of these records would be relevant because they show other course of study, but as far as the criminal litigation and criminal investigation, they will be. So you need to redact these records to comply with that. What's the next exhibit?
Your Honor, the next exhibit is a composite of 210, and I don't know if this one is the course book material as well as the homework from the criminal litigation class. Mr. O'Meara at one point indicated that he wanted the entire course book entered, and so I have that available. I'm not sure whether that's still the desire. The other part is just the section relating to self-defense.
Now, is there a live witness who's going to testify as to these exhibits?
Yes, Your Honor. Professor Carter is here.
Do you want those after the exhibit?
These all have them.
Okay.
Okay, I guess there's two parts of Exhibit 210. The first one are different homework assignments.
Yes, from the course.
And a final project paper.
Yeah, continue to be heard on the objection that I was outlining before.
On this Exhibit 210, yes.
Actually, on all of them. I don't think the state can create evidence and then, for the sole purpose of impeaching it. They introduced the Sean Hannity. They left in that portion about standing ground, and now they're trying to bring in additional evidence to try to impeach Mrs. Zimmerman on what they put into evidence. So I think, and I don't have the case law right here, but I'd be glad to present it to you, that they can't create evidence. They can't ask a question the way they did.
They didn't ask the question.
Well, they presented the evidence.
Okay.
And they could easily have redacted that had they had the concern to. They left it in solely for the purposes of bringing in suggested impeachment to say that he did say something or know something when he didn't, when he said he didn't. So they can't create their mild problem by putting in evidence solely so they can impeach it, Your Honor. I think that that is unfair. It's inappropriate, and they shouldn't now be able to come in and impeachment. So that's sort of as an aside to what they're attempting to do.
Wouldn't that be the same as declaring a witness as a hostile witness?
Well, I think what they're doing is they can't open their own door, Your Honor. I think rather than impeaching as a hostile, what they cannot do is, as you sort of suggested last week in the trial, you can't open the door a little bit yourself so that you can push through it. And that's what they're attempting to do by leaving that in to an otherwise redacted statement, just as an attempt, a foothold, if you would, to get in evidence that now might suggest, not in the book, because the book says nothing about standing ground, but that some professor may come in, acknowledge that George was not even in class that day, and talked about standing ground. I presume that's what they're going to have him testify to. And they can't simply create their own impeachment evidence. which is what they're doing with that particular attempt.
Well, I'm going to have to give you time to look at some case law on that, because I don't know at this point in time that I agree with that.
The state's position would be, although it is impermissible to call any witness for the sole purpose of impeaching them, that is certainly not the reason that that exhibit was admitted, and I would point out that it was admitted upon stipulation of both parties.
Right, and the court even read the instruction to the jury that portions had been redacted, so that creates a whole other issue.
And as to the school records themselves, even, I understand the court's ruling as to some of it, but even as to the other ones, again, I don't think it's appropriate for the state to focus this jury on evidence of my client.
But that's their case that they're trying to present to the jury. That's their theory of the case. And they're allowed to present evidence on their theory of the case, just as the defense is allowed to cross-examine their witness on their theory of their witnesses on your theory of the case.
My understanding is that there at least there needs to be some connection.
Okay.
That they can't just allege that he took a class in junior college a couple of years prior, and therefore then ask the jury to presume something without some direct evidence. And to date, there has been no direct evidence connecting any of that together.
Well, your cross-examination of the different witnesses regarding the incidents that occurred on that night gave an indication that the jury could infer that your client did not have any information about what self-defense means or is, or an understanding of the criminal justice system. So I think that that's before the jury based upon that. So if it's the theory of the state's case that Mr. Zimmerman had that information, or at least understood the process, I think they're entitled to bring that forward. If you would like a few moments to get some case law on that, I'll recess for about a half hour, and you have people there helping you. You can go ahead and try to find the case law.
As to the request for the proffer, then, can I at least request that the state proffer that they're going to be able to connect up? As an example, I mentioned a moment ago, if they're going to suggest that my client knew about stand your ground, would they not need to at least present evidence from their witness that my client was present during some coursework that was given? If not, then it's pure supposition, and I don't think it would be then the relevance is not bridged. That's what I was talking about a moment ago, maybe not artfully, but if they can't connect the dots at all, they can't just allow this jury to sort of guess as to what it means. So if standing ground is going to be an issue, and they now want to show he was there for standing ground, shouldn't they at least show he was in class? And I asked for that proffer.
So I'm going to say one thing about that is we've now moved again, as so often has happened here, from the original objection to 4 different points removed from the original objection. If we're now asking for a proffer about whether or not the defendant was present, I think it misses the point. The point is he had access to this information in the book, he had access to the information from the class, and
I haven't seen the book.
And that makes it, you have the chapter in front of you, which is a portion of that exhibit.
The self-defense chapter
Yes,
7
Your Honor.
is the portion?
Yes, Your Honor.
That came from the book?
Yes, it did. And the relevance of all of this, again, taken together, is that the defendant did have this information or access to this information. Whether he wishes to claim that he wasn't there that day, or whether on cross-examination they wish to ask the professor whether or not he could guarantee he was there that day, that goes to the weight of the evidence, not whether or not it's admissible in the first place. It's relevant evidence. As far as the idea that it's more prejudicial than it is probative, it's odd to first say this is good things and then argue that it is so prejudicial that it is unfairly prejudicial to the point that any relevance it has is outweighed. Those two arguments are completely inconsistent with one another.
Let me try and make them consistent, because
Okay, now let me go ahead and do this, because we could go back and forth on this and all the time, and I'd rather give you the opportunity to go back and do a little bit of research. We'll be in recess for 30 minutes, and let me see what case law can be provided. The other 2 exhibits before we recess on this are...
One is an application to be a police officer.
And what is the date of that application?
That is, it was
July 8th, 2009 was when that was resolved.
Okay, and the other one is an application to ride along. What is the date of that?
3/15/2010.
Okay, I will consider all of those. We'll be recessed for half an hour. Thank you.